Hi, everybody, and welcome to this edition of Judgment Day. I'm Lorne Honickman, and this is the webcast slash podcast where I go over some of the very important court rulings and judgments that come out of the courts right across the country. And of course, some of the most important judgments come from Ottawa, from the Supreme Court of Canada, because those are the judgments that may have the greatest effect on all our lives. And just hours ago today, the Supreme Court of Canada came out with their long-awaited judgment on the federal government's Greenhouse Gas Pollution Pricing Act, or better known as the Carbon Tax Act. You know what I'm talking about. That's the piece of legislation that the government passed in 2018 that based on what they felt was a consensus that greenhouse gas emissions contribute to global climate change. And the whole question, of course, was whether or not the federal government had the constitutional authority to put this type of legislation into place. And some of the provinces like Ontario, Saskatchewan, Alberta, they said no, that Ottawa should not have been able to do that, that this is something that only the provinces can do. And that was litigated. And the court today, in a 6-3 decision, said, no, the act is constitutional. And yes, the federal government could do what they want to do with this particular piece of legislation. So that's what we're going to talk about. We're going to go over the judgment, a fascinating judgment, because as I said, was 6-3. And some of the dissenting opinions, like the one from Justice Brown, was very, very strong, had a lot of problems of what the majority did. So let's talk about it. In order to do so, let's bring in a lawyer who is developing a career in constitutional law. Indeed, has been published on the subject. We'll call him one of Canada's best young constitutional lawyers, who also happens to be my son, but that's, I guess, beside the point. Asher Honickman. Welcome, Asher.
Thank you for having me, Mr. Honickman.
Mr. Honickman. See, I taught him well. All right, let's get into this, because it's a pretty serious judgment in the sense that the distinction between how the majority looked at this and how some of the dissenting judgments were. But let's first of all talk about what was really the essence here of what the court was looking at, because that's the I guess the interesting part about it, because this judgment talked about what I guess we would call a rarely applied doctrine of Canadian constitutional law that deals with national concern. So let's talk about that, Asher, and what the court found there.
Okay, so the first thing to understand is that we have a constitution that divides all legislative power between Parliament and the provincial legislatures. And what our constitution says again and again and again throughout this part is that these powers are exclusive. So what Parliament can do, only Parliament can do. What the provincial legislatures can do, only they can do. And both orders of government, both Parliament and the provincial legislatures, have residual authority aside from all the enumerated powers they have. And the federal residual authority is called peace, order, and good government. POG, we call it for short. And POG has two elements itself, either a national emergency or national concern. Right. And so what the courts have done over the years is that they've said, even though certain things might not be enumerated, if there's a national emergency, Parliament has the exclusive authority to deal with that. Or if there's something that is so indivisible and has such a singular character that only Parliament can deal with it, it has a national concern to it. Right. And so it becomes federal authority. And we'll get into this, but it's important to understand the distinction between national emergency and national concern.
Right. And they found here that it was a national concern. And just to quote Justice Wagner, Chief Justice Wagner, when he talks about it, he said Canada, and he's referring to the government passing this legislation, must establish that the matter is of sufficient concern to the country as a whole to warrant consideration as a possible matter of national concern. And that question they answered in the affirmative, right?
That's right. And what's important to keep in mind too is that this case from the beginning was argued as a national concern case.
Right.
The difference between national concern and national emergency. An emergency by definition is temporary. And what Parliament does in a national emergency case is they go before the court and they say, look, we know that this is provincial jurisdiction, but there's an emergency. And so we've got to take this over right now. This is going to temporarily become our jurisdiction. National concern is different. What national concern says is it doesn't actually matter what's going on. It doesn't matter if change is an emergency or if it's being exaggerated. By virtue of what we're doing, this is national, and it will always be national, and it will be exclusively national. So they're taking away a provincial power for all time. And this was really the key here. Parliament did not come to court and say we have a climate emergency. They talked about that in the facts, but that's not fundamentally what they were saying. What they were saying is that this is just fundamentally national in character.
Right. And Wagner, the majority, agreed with the argument that the federal government, when they come out and they say that climate change is this pressing matter of national concern, these are the key words here, and it's constitutionally permissible for the government to take the lead on this, even though it crosses provincial boundaries. And that to me was really interesting, because even though courts, as we know, aren't really supposed to get into the politics and the controversy, but the majority through Chief Justice Wagner made it clear that they talked about climate change being something that's real. I think they use those words, that it's caused by greenhouse gas emissions resulting from human activities, and that it poses a threat to the humanity's future. Even using those words in a judgment seems to, well, to me, to try and say, this is why we believe we can put this into the national concern category, if you will.
That's right. There's no doubt that policy was animating the majority opinion, and the lack of policy consideration is what was animating the dissent, and what animated, the dissent of Justice Huscroft in Ontario, what animated the majority of the Court of Appeal of Alberta. You really see a disconnect there in all of these decisions where the majorities are talking about the danger of climate change, which strictly speaking has zero relevance to a national concern argument. It would have a ton of relevance to a national emergency argument, but it doesn't matter really, strictly speaking, for a national concern argument, because really what you're saying there is that even if climate change were solved tomorrow, even if we found some way of invented something that could suck up carbon, let's say,
right,
this action of the federal government setting minimum standards for greenhouse gas emissions would still be a concern. That's the implication of this decision.
Right. And just so everybody understands this, because, you get these decisions and people say, okay, so why am I caring, etc. So the government, let's just put this into a perspective here. The government passes this law in 2018. And what this law, or what they state through the law, is they're setting what they call the minimum national standard for pricing greenhouse gas emissions in industry and consumers. But they say, if a province has its own carbon pricing regime, and I guess that's Quebec and BC have that, and it meets these, quote, minimal standards, there's no problem. But if the province doesn't, like here in Ontario, for example, then that's why the federal, quote, carbon tax has to come into being. So their argument being, we're just making sure that everybody's doing what they're supposed to be doing. That's what that argument seemed like to me. You can do it. Okay, province, go ahead, do what you have to do. But if you don't do it, we have to do it for you. That's what it was like to me when I read it.
Yeah, well, that's really what the law says. And you know, to give Parliament some credit here, what they didn't try and roll over all the provinces. They basically said, we're going to let you do the right thing first, but if you don't, we're going to do it for you. The problem with that is that it sets a precedent for that kind of legislating in all areas of governance. This idea that Parliament can say, look, provinces, you can set up proper healthcare, you can set up proper electricity regulation, you can set up proper highway traffic legislation, but if you don't do it properly, we will do it for you.
Well, that's the interesting thing, isn't it? What you just said, you used highway traffic as an example. So now let's look at what this judgment means, because that's what happens a lot when we talk about important judgments from the Supreme Court of Canada and how they could be used. So I want to talk about that, Asher, about what you just said about highway traffic. Clearly, highway traffic matters are a provincial matter. So in Ontario, it's speeding if you go over whatever it is, 100 kilometers here, etc. So are you saying, could this be that if Parliament wanted, I don't think they'd do it, but if they wanted and they took a look and they said, you know what, speed limits across the country should be 80 kilometers, and we want all the provinces to do that. And if they looked to Ontario and said, oh my goodness, you're still leaving it at 100 based on this decision, could they come in and say this is a national concern? I mean, it may be bizarre, but does it open that door?
It opens the door. Now, what the majority would say is that is a misplaced concern, and the majority talks about this, that it's not simply minimum national standards. There has to you have to meet all these other tests to get in. One of the big things is that there needs to be this provincial inability, and so what a court may say in the context of highway traffic is, well, there's no provincial inability here. Provinces can regulate this, but you can certainly imagine a scenario where car accident deaths are skyrocketing, and people start talking about provinces are not doing enough to prevent motor vehicle accidents, and Parliament comes out and says, on any highway in Canada may ever go above 80 kilometers an hour. Doesn't matter if you're on a 400 series, doesn't matter if you're in a residential neighborhood, 80 kilometers an hour is now the highest you can ever go in Canada. And the reason we need to do that is because the provincial legislatures have been irresponsible. Some are letting you go 100, some have even said 120. Deaths are skyrocketing. Clearly, provinces can't deal with this. Now, there would, of course, in a case like that, there would still be tons of arguments to distinguish climate change, because carbon moves across provincial borders in ways that cars don't. But as Justice Brown pointed out in his dissent, and we'll talk about that, when it comes to climate change, we know where all the polluters are. We know where all the carbon is coming from. Maybe it moves across provincial boundaries, but we know where it starts. And so it's not that dissimilar. And at the very least, this decision would raise a live issue about whether a law like that would be constitutional. It would cause a lot of litigation. And in the end, yes, maybe it could be distinguished, but we don't know. That's the point.
Yeah.
It opens up a lot of doors.
And I just found the passage in the judgment talking about the national concern doctrine. There must be, quote, provincial inability to deal with the matter. And they say, what is that? This is the quote: failure of one or more provinces to cooperate would prevent the other provinces from successfully addressing it, and that a province's failure to deal with the matter within its own borders would have extra provincial consequences. So that's what you were saying, that if a province is not dealing with this matter, and it now is going to affect another province, now you're getting into this national concern doctrine.
The problem is, who decides that? I mean, there is not one province in the Federation that is not dealing with climate change in one way or another. So who decides that Parliament needs to, quote unquote, step in and address a vacuum, essentially? And the problem with this whole line of jurisprudence and thinking is that it presumes that a choice not to act in a specific way is equivalent to an inability to act. And we have to be very careful not to conflate those two things. An inability to act means truly that the province cannot do this. But the very nature of this law presumes that the provinces can do it.
Right.
Parliament has said, provinces, you go ahead and do this, but if you don't, we will. By definition, that is not inability. A province might say, no, you know what, federal government, we don't like a carbon tax or pricing. We would rather bring in maybe a real tax, or we would rather bring in that kind of regulation, this kind of regulation.
Right.
Whatever it is, these are all policy choices. So for the court to now get into inability, I'm just wondering, what evidentiary record are they going to decide that on?
Well, and they did say you need evidence, but again, dealing with that and what we're talking about, it's like the Chief Justice says that, and again, trying to make sure that nobody's doing what we're trying to do here, or sort of thinking of doing and extrapolating this further, saying that this is not the matter here is not just the regulation of emissions generally, and Canada's not seeking to have all potential forms of this type of regulations classified as matters of national concern. So he talks about the specific question before the court is whether establishing these minimum standards is a matter of national concern. So he tries to make it narrow that way. But let's go to the dissenting judgments. And a lot of people, just so everybody understands, if 6-3, 7-2, whatever it is, 8-1, whatever it is, it doesn't really matter at the end of the day, because once the court makes the decision and you have the majority decision, that's it, even though history will show that 3 judges dissented. But because this case, in my mind, and I'm thinking you would agree as well, has a lot more significance, if you will, beyond the actual case itself, about how the Supreme Court was really looking at this issue. Justice Brown, he had a very, very, we'll call it a vocal dissent. He says the majority's reasons for judgment are momentous. Let's talk about that. What was he really concerned about?
Well, he's fundamentally concerned about the Constitution. The Constitution establishes 2 exclusive orders of government, 2 exclusive spheres of jurisdiction, where this national concern idea is really supposed to be this residual thing. It mostly covers things that didn't exist at the time of Confederation, like airplanes, like radio, telecommunications. These are things that you say, okay, well, airplanes, even though there's nothing in the Constitution that says aeronautics, airplanes, because they're flying over the entire country, that's a fundamentally, quintessentially national object there. This is something that has historically been provincial. The regulation of greenhouse gas emissions, really energy in general, has always been a very provincial matter. And I'll push back a bit against what you said about that whether a decision is 9-0 or 6-3 doesn't really matter. You're absolutely right that it doesn't matter as a matter of law, but as a matter of practical application, it does matter, because what Justice Brown's dissent and Justice Rowe's dissent and Justice Cote's partial dissent, what they really are, they're like a big warning label on medication that says, caution, consume at your own risk. And that's the message that it's sending to lower court judges and to lawyers who are ever going to want to come into court and argue national concern. It is saying this majority judgment is fraught with problems. It doesn't make a lot of sense, and here's why. And if you try and apply it to something else, you're going to have problems. And I think that's evident just from the majority judgment itself, because in order to get those 6 judges on board, and I think especially in order to get 2 of the 3 Quebec judges on board, the majority had to cast the matter in very specific language, in such a way that one could argue that, that there really won't be any other application of this, that you had to confine this so narrowly to just the facts of this case that one wonders really whether it will be able to be applied in the future,
Right.
especially with Justice Brown's dissent showing why it would be so dangerous to apply in another context.
Right. But at the end of the day, as you know, that may have some effect, as you say, in future legal decisions and legal arguments. But let's be clear here for everyone out there right now, for the federal liberals today, this is a clear victory. The dissents, as loud as they are, is not going to make any difference as to what the government now does on a go forward basis.
That's right.
That's right. And
it's actually an incredible victory. Here's why. There was never any doubt that Parliament could tackle climate change. And this is the fundamental point that your listeners and viewers need to understand. Parliament could have tackled climate change in any number of constitutional ways. First and foremost, it could have actually passed a carbon tax. We call this law the carbon tax. It's not actually a carbon tax. Right. Parliament has broad taxing power, much broader than the provincial government, than the provincial legislatures do. So it could have passed a tax. It could have declared an emergency. It could have passed new criminal laws. It could have passed a whole variety of laws under its trade and commerce or federal undertakings powers. It didn't do any of those things. Why? Because if you're going to pass a tax or if you're going to declare an emergency, there are political consequences that go along with that. Parliament wanted to have its political cake and eat its I
know what you were trying to say.
Too. I tried to be too clever there and I mixed myself up. But that's essentially what happened. Parliament wanted to have all the benefits of a constitutional law, but not have to go to the public and say we're passing a tax or we're declaring an emergency. And so this is really a huge victory because now it has a constitutional law that it has with almost zero political consequences.
Right. And interestingly, and this happens, and this is the way it goes when politics, when you have that part of government, it's the legislatures who make the laws. And then what we have heard politicians, Mr. O'Toole, talk about completely repealing this law. And you can imagine, like, you go to court and this is litigated, and then a new government comes in and they literally, so people understand this, with a stroke of a pen can take this off the table. But I think what you said is important, that people understand this, because the Supreme Court felt it was important that everyone understands it, that the term carbon tax, well, it's been used in this case, that it has nothing to do, as you just said, this regulation has nothing to do with the concept of taxation. But for everyone else, for those who are out there and they're not in the courts and they're not reading this, what I think what they have to understand is that at some point, one way or the other now, potentially, there is going to be what people are concerned about, what's going to be coming out of my pocket. And that's what do you think about that? Is it, do we all sit here now and say, with this ruling from the Supreme Court, one way or the other now, something is going to be coming out of my pocket?
Oh yeah, I mean, that's the entire point. Now, I'm not an expert on the policy. People who defend the policy actually say that, many people will say this is the most conservative way to fight climate change because there are offsets and average people will actually end up paying less in the long run. I can't speak to that. Not many people, I think, really can speak intelligently to that. A lot of people have ideas on both sides. But yes, there's no doubt, and the court talks about this, that the pricing, even though it's targeting producers, it's like an indirect tax that will get passed on to consumers. It's like, it's no different in that way from a duty that gets imposed on imported goods. That those duties always get passed on to consumers.
Right. And just going back to Justice Brown, Asher, when you look at his last paragraph in this judgment about what he thinks the ramifications are, I just got to just read this because this is a judge speaking through his ruling. Listen to the message he's giving to the Canadian people. I just want to read this. No province, not even Parliament itself, ever agreed to or even contemplated either of these features. This model of federalism that rejects our Constitution and rewrites the rules of Confederation, its implications go far beyond the Act, opening the door to federal intrusion by way of the imposition of national standards into all areas of provincial jurisdiction, including intra-provincial trade and commerce, health, the management of natural resources. It is bound to lead to serious tensions in the Federation, and all for no good reason, since Parliament could have achieved its goals in constitutionally valid ways. I dissent. I mean, for those of us who every day read judgments, when I read those words, I thought, oh my goodness, this is a judge that is sending out a very direct message to everyone in the country.
Yes, and it's the warning label I was talking about before. They are chilling words. They are brilliantly written, and he has another. I don't want to turn this whole thing into the Justice Brown love fest, but a bit before that, he talks about balance, and this is another brilliant paragraph of his, because he says the role. He first says the Attorney General talks about striking a balance of federalism, and this is a big theme in the jurisprudence. We want to strike a balance. We want the provinces and Parliament, cooperating. And what Justice Brown says is the role of the courts is not to strike a balance, but to maintain and preserve the balance that is already recorded by our Constitution in its division of powers.
Interesting.
Your role, judges, is not to figure out the best way to have Parliament doing what it wants to do and the provinces doing what they want to do. That balance was already struck in 1867. You just need to make sure you don't upset that balance, and you are absolutely upsetting the balance with this decision.
Interesting. All right. Well, it's going to be like all important judgments from the Supreme Court. It's going to be very, very interesting as to what happens now, how the provinces react, whether they simply now just say, okay, we'll do it. We'll take care of this now. But everybody has to understand that there will be some sort of ramification from this judgment today. Remains to be seen exactly what it is, though.
I mean, we're in Ontario. I was talking to a friend in Alberta who said that people there are very upset about this already. This is a big country, lots of different interests, and lots of people who don't necessarily think like the 9 justices of the Supreme Court of Canada, who have different experiences and different perspectives.
Well, and this is why there's a show called Judgment Day, because one of the things I want to do is make sure people understand that sometimes when those 9 judges decide issues, it affects people from one end of the country to the other. And we put a lot of faith in these people, but that's what our rule of law is all about. And so today, this judgment will go down as a 6-3 decision, and legal
7-2-6-3.
7-2-6-3. That's true. It'll be sort of around there. All right. Thank you for joining me today.
Thank you for having me.
And I guess I wouldn't say this to all people who will come on the show, but hugs and kisses to everybody in your house.
Same to you.
All right. I'll talk to you later. Asher Honickman. And it is going to be very, very interesting when this all comes out in the wash, if you will. But a very, very interesting decision. And you can see how Asher and I have the discussion going over the different ways of how these judges looked at it. But that dissent by Justice Brown, when you read the words like that, you don't normally see, I put normally in quotes, such strong wording by a judge of our highest court. Very interesting. Okay, so that is this edition of Judgment Day. Thank you so much. Again, I'm not on Facebook or Twitter, but I'm very accessible at my law firm, Brody Thorning in Toronto. You can send me an email, lhonickman@btlegal.ca. That's bobtomlegal.ca. And I'll be happy to respond. And you can let me know what you think of the show and topics and questions that you may have. And so until next time, bye everyone. Thanks for joining me.